a handful of major generative AI companies that generate text, image, video, et cetera, using AI models, are getting sued for their use of copyrighted or protected material in training those AI models. So this is a development that has pretty significant implications for anyone who is using tools that use AI to generate text or images. So one big impending lawsuit comes from the stock photo company Getty Images, and they are threatening legal action against Stability AI. Getty claims Stability AI used millions of copyrighted stock photos and images to train its stable diffusion image generation model. Stability AI is unfortunately also being sued by 3 artists who are levying similar copyright infringement claims. And they're also, as part of that lawsuit, suing Midjourney, another AI image generation company. And on top of all of this, GitHub, which is a code repository, it's very popular among programmers, and the company that owns it, Microsoft, are being sued over a tool called Copilot. Now, Copilot is a very popular AI tool that generates code for you. It's also a generative AI tool. And the suit alleges that Copilot was actually trained on GitHub's public code repositories. And some of those code repositories are actually protected by open source licenses. And, as an aside, OpenAI actually is also named in this lawsuit because their models power Copilot. Now, all of these are pending and just kind of getting started as legal actions, but they're really kicking off this aggressive public debate about the fair use of content that is being used to train AI models. And these models, these handful of really seminal important models, are being used by hundreds, if not thousands, of AI startups, companies, and projects. So they're all relying on these models, which are now being challenged in court about their use of copyright material. So I think it's still too early to say which way the wind will blow on this, but regardless of outcome, the cases are going to set important precedents and have pretty far-reaching consequences for anyone who uses AI. And they're probably, I would think you would agree, just the beginning of what it will probably be a wave of legal actions. So what are your thoughts on the overall copyright concerns being raised here?
I'm not a lawyer. We'll start off there, nor do I pretend to be one. I did take business law a really long time ago. It's actually a fascinating class. I thought about being a lawyer for about 3 weeks before I went into journalism. um, anyway, so I see 2 major issues here. Well, probably more than that, but we'll start with the 2. So the first is the training data. This is a known issue that the language models are trained on data that they probably didn't get permission to train on, and the image generation models also are trained. The video models will be the same. Anywhere where this occurs, there's going to be this question of where did they get the training data and did they have permission? So you're seeing some backtracking now where like Stability AI's CEO is actually not commented specifically on this case that I'm aware of, or this suit, but at least in general said, hey, we're going to find ways to let people opt out of our next model where it's basically like a do not train on AI with my content sort of thing. You're seeing stuff like Shutterstock, I know, has a deal with OpenAI where they're, I believe, trying to compensate the original artists for the training. I don't pretend to understand how that would work or how it would ever be an equitable exchange for training. So on the training side, the arguments I have heard is, let's say I go read 10 articles about generative AI, and then I synthesize that learning and I write an article about generative AI. Here's 10 things to know about generative AI. Now I'm combining the 10 articles I wrote into my knowledge base to produce that article. The argument you'll hear from OpenAI and others is, what's the difference? If the AI goes and reads 10 articles and synthesizes its findings and it writes original content based on those 10 things, what does it need to cite them for? It's not citing specific information. It's synthesizing learning, which is what we do as humans. So the Supreme Court case that seems inevitable to me could come down to this very argument of like, what is the difference between how the AI learns and how the human learns? The AI is not copying and pasting. It's not stealing anything. It's not scraping anything. It's learning. If I wanted to paint like Picasso and I had any artistic ability whatsoever, which I don't, I could just go study the entire library of Picasso works. And then I could create an original image in the style of Picasso. Am I am I plagiarizing? Am I stealing? Am I infringing on anyone's copyright? I don't believe I am in that instance. So again, what is the difference? I am not saying I'm in that camp. I'm not saying I agree with that. I'm just saying this is the argument you're going to hear and why lawyers exist to fight these things, and why the Supreme Court exists to decide these things in the United States. The other issue I see here, though, is the fair use of content, where you are potentially limiting someone's ability to make money. So,
Hmm.
if like right now, the way Google gets around this is they provide links. You could question whether Google snippets are actually infringing on people's ability to generate value from their creation, because they just present the answer. But in the case of a language model generating a response, so like the example I've heard in a number of podcasts is like a restaurant review or whatever. Um, what's the best Irish pub in Cleveland, to get a burger and a Guinness kind of thing. And if ChatGPT just replied and said, go to PJ McIntyre's in West Park Station, um, and get this burger with no citation whatsoever, but it actually got it from Yelp, like that's a difference. Did it get it from Yelp or did it not? Because if it got
Hmm.
it from Yelp and didn't give me a link to Yelp, then it just infringed on its ability to monetize its data and its, commercial assets. And I just went to PJ McIntyre's without having to click on any links. So what the argument is now is like, well, you need the links, the citations in there. Well, that's assuming that the output of the language model has a citation to be had. It
Hmm.
did. It didn't get the information from Yelp. It actually curated probably 10 or 20 sources about best pubs in Cleveland. There was a Cleveland.com article and wherever else people get their food information from. And out of that, it's synthesized that you should go to PJ McIntyre's. So the case I keep hearing is, well, we'll just infuse citations into it. And I've seen like startups popping up that are doing citations. I've seen, Sparrow, we talked about last week. DeepMind is working on citations. And I was like, citations of what? That's not how the model works. So it's really confusing to me where this
Yeah.
goes from to make it tangible to people as a brand. I would be very cautious about how you're using these tools, because if you're using a third party tool that is leveraging these APIs, like access to say OpenAI to use this, and all of a sudden OpenAI gets in trouble for where their language model came from or how it was trained, you may be building a business on top of something that you might not have access to in the near future for whatever legal reason may exist. If I'm an investor and I'm investing in these different platforms that are building on the APIs of these companies that might be in legal jeopardy in the near future, I just I have no idea what the legal precedent is going to be here or when it's going to occur,
Hmm.
but it sure seems inevitable that lawyers are going to be clamoring for class action lawsuits on this stuff. Like, basic knowledge of how the legal industry works, we're looking at billions or trillions of dollars in market value to be created. They're going to want a piece of that because there are questions to be asked, rightfully so, and there are legal cases to be brought. And I would just exercise caution as people that use these tools, as investors in the companies that build these tools, and as the companies themselves. Like I think we talked about it maybe on the last episode, I, of like, is Sam Altman going to have a Zuckerberg moment? You can just see Sam Altman sitting in front of Congress getting grilled on how language models work, and which side of the aisle chooses to take on language models first is basically, I think, where we're at right now. So I gotta guess 2023 we're going to see some crazy legal cases at least moving forward where these questions are going to get asked a lot more. And I just would encourage people to pay attention because it's going to affect you as an
Yep.
end user, as an investor, as a company that's building these things. Um, this is, it's not a clean story of how this stuff got built and where it's going to go from here.
And so, just to clarify here for maybe some people that are newer to this topic, when we're saying be cautious or be careful, and again, none of this is legal advice, we're more advising that you may want to be aware of how much of your strategy or your efficiencies or your business planning are relying on certain models or tools that could run into trouble down the line. As far as we can tell, though, you're not breaking the law by using a Dolly 2 or using a generative AI text generator. So businesses don't necessarily need to worry about, oh my God, should I be using this tool at all? It's more about, you're saying, taking a longer view of paying attention to these cases, the precedents, and how you're using the technology. Is that correct?
Yeah, I mean, I'll give you a practical example. If you use AI to create an icon for your logo, my
Mm,
understanding today is you cannot copyright an AI generated logo. So
mm.
if you wanted to get a trademark, or you not copyright, you can't get a trademark on it.
Trademark.
Um,
Okay.
but in a copyright, so like we actually submitted some materials for copyright to the U.S. Patent and Trademark Office for copyright, and there was AI generated image in the decks, and those can't be part of a copyright.
Hmm.
So again, I'm not giving legal advice, but what I'm saying is if you're generating content through AI, can you hold the copyright to the content? And if you're generating images or video with AI, can you protect those in the same way you would traditionally protect things you would create for your organization? So the intellectual property, talk to your attorneys, get an IP attorney, get somebody who
Yeah.
knows is studying this space because it's so new. You're going to go find experts in generative AI, but find IP attorneys who can advise you on this stuff, who can keep track of the current case laws and give you the best guidance they can, is I guess my recommendation here. That's what we've been doing the last couple months with a lot of the AI stuff we've been working on, is what can we even protect?
Yeah, there's probably a golden opportunity outside of doing the actual legal work for some enterprising attorney out there to release some type of guidance or product on this
Absolutely.
topic.